is Texas now session. So to adjourn, God save the Constitution and the laws of the court.
Please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon, case number 01-21-00155, Civil Constellation Brands, Inc. and Frederick Schrader versus Robert M. Roach. May we have appearances, please?
Good afternoon, I'm Casey Lowe, and I'm here representing the appellants, Constellation Brands, Inc. and Fred Schrader.
Thank you.
Good afternoon, I'm Robert Bose, and I represent Mr. Roach.
Thank you. And is it correct that the appellant has reserved 5 minutes for rebuttal?
That is correct, Your Honor.
Okay. With that, let us begin when you're ready.
May it please the court. In the words of the appellee in his Fifth Amendment petition, a 10-minute internet search of the records of the California Secretary of State would have revealed the existence of an LLC entity between Schrader and Roach. He tagged that with my clients, but he also doesn't say that he would have revealed the dissolution of that entity. And what this case is here on is a TCPA motion, because this appellee has sued my clients to dissolve their sale and to take action that violates their right to petition and their right of free speech and association.
May I stop you there to ask you, which version of the TCPA are we talking about here?
That is a difficult question, Your Honor, and I'm glad you asked. A cause of action is defined broadly under the TCPA to be either the suit or the claim, and we believe that the amendments changed based upon which cause of action was on file whenever the TCPA was amended.
Isn't there a case out of the Texas Supreme Court, though, Creative Oil, that interprets the word action in the statute to say that the old version of the TCPA applies because the new one only applies to cases filed after the September date, which would put this case under the old TCPA, right?
That's correct, Your Honor. And what I meant by the claim being under the new TCPA also is that even under the claims that are on file afterwards, but for that case, the analysis is the same. We're asserting that the right of petition occurs because of the actual agreement between the parties, the appellants, which under the old version, the right of association rather involved communications as well. That's not an issue here. What we're asking this court to do, though, is to, on de novo review, dismiss the appellee's claims in this Fifth Amendment petition for 3 reasons. First, the new claims against Fred Schrader are no more connected to the forum contacts in this state as the old claims that this court dismissed on its special appearance earlier this week. And so we would ask that all of those additional claims which we've moved on under the special appearance be dismissed. Second, the new claims and the new facts pled against my clients implicate the TCPA because they now put at issue for the first time communications with the Patent and Trademark Office. They now put at issue for the first time communications about an ongoing lawsuit, thus implicating the right to petition. And third, that the claims are meritless. And the easiest way to see they're meritless is that they're barred by limitations under any analysis. But if you look at the individual claims that are left, especially those that are remaining after being dismissed on jurisdiction, they all turn on an intent of Constellation which had no knowledge of Roach's existence, much less some meeting of the minds to take property from him. I'll start with first.
I'm sorry, Mr. Lowe, with regard to the claims that you say are implicating the TCPA here. So the trademark applications and the lawsuit in California and the attorney grievance, weren't those done by Schrader and not by Constellation?
Those were actually the lawsuit in California is by Schrader Sellers, which is a subsidiary of Constellation. And so those would be part of Constellation and Schrader together. But also we're asserting that the suing on the Constellation letter, attorney letter in response to Roach's demand letter, is an action by Constellation that's a right to petition connected with this lawsuit. So you're correct, Your Honor, there are some that are solely Fred Schrader, those are the grievance actions and those actions, but I do believe the lawsuit as well as the attorney letter from Constellation is the right to petition for Constellation. As far as that goes, I'm happy to go to that point first, since I know this court is very familiar with the personal jurisdiction issues, having rendered an opinion very recently on it. But the right to petition is essentially seeking governmental adjudication of something. And in this instance, they've asserted that my clients have committed fraud on the Patent and Trademark Office by applying for a trademark on RBS and other Schrader sellers' marks. And they've done that for the first time in the Fifth Amendment petition. That triggers the right to petition and thus the TCPA. They've made it the basis of many of their claims of fraudulent intent, conspiracy, joint action, and thus that's why this court's role is to review those claims and determine if there's clear and specific evidence for them.
Well, aren't there references to the trademark in the prior petition as well?
The only reference in the trademark to the prior petition that is in both petitions is that was not trademarked prior to the sale. And what is in the new petition that's not in the old petition is that the actual effort to get the trademark issued before the sale was fraudulent and intentionally depriving Roach of his assets. He's argued, the appellees argued, well, you can infer that from the original petition, but that's, I think, would fly in the face of the Texas Supreme Court's recent holding that said, no, you don't really infer new facts. If they're new facts and they're relying on them, or they're new claims and they're different claims, then the TCPA is implicated anew, which it was in this case. They cited the case that was abrogated. We cite the Texas Supreme Court case that did abrogate it, that says this court has authority to review under the TCPA a new petition which asserts either new facts or new claims, and in this case, appellee does both. The other thing that appellee did in the Fifth Amendment petition that he did not do in the Fourth Amendment petition was add numerous claims asserting some sort of conspiracy or implicating the fact that my clients are represented by me, both of them, or that they have an indemnity agreement, or that they're in joint cooperation with each other, which again implicates the right to petition. If they can't choose their own counsel or they can't enter into an agreement that allows them to be jointly defended in a lawsuit, that is chilling that right that all defendants have. And that's one of the reasons the right to petition is covered by the TCPA. As to the claims themselves, though, as I understand this court's ruling from earlier this week, all but the fraud claim against Schrader has been dismissed. The new claims that are added in the Fifth Amendment petition against Schrader all relate to the partnership and the other California contacts that this court found were insufficiently connected to Texas, and thus all of the additional claims against Fred Schrader should be dismissed on the special appearance. But the claims against Constellation basically boil down to two things. First, they boil down to this notion that Constellation somehow conspired with Fred Schrader to cut out Randy Roach, when there's no evidence in the record of that. There's certainly not clear and specific facts suggesting that, because all of that evidence shows is they had an NDA, they did diligence, and they never found anything. There was no official claim of ownership, there were no official records at which one would discover.
Wasn't there some an expert affidavit in this case?
There was an expert affidavit offered in response, as part of a motion for summary judgment Mr. Roach filed that was ultimately stayed. The theory being that Constellation would have some sort of inquiry notice under Texas law, which, setting aside that that's a legal opinion that I think is legally insufficient to suggest anything, also demonstrates that there is no actual knowledge by Constellation of any right of Roach to ownership. What he's suggesting is they should have searched the internet, and what they would have found was RBS LLC. But they also would have found that RBS LLC had been dissolved in December of 2013. And had Roach bothered to do that, he would have too. He had a duty to monitor. We cited to this court the Berry versus Berry opinion from May in the Texas Supreme Court, that when you have a duty to monitor your rights, and in public filings, if there's a public filing that injures you, that starts the clock for limitations. Even if you're injured additionally later, even if you claim that you didn't know, even if you claim fraud, because the diligence of finding that would have unearthed it. In this case, had Roach actually looked at the public LLC filings of his own entity, he would have found out that his interest that he claims through that LLC is gone. And we tendered 2 exhibits to this court. I've never tendered an exhibit to an appellate court before, but I think it's because they're so clear. Exhibit 1 is the public dissolution of that entity. And Exhibit 2 is, before that was filed the same month, Mr. Schrader saying, I'm going to dissolve this. And nothing was done. And so limitations is the easiest way out of the 75-page myriad of claims that are asserted. And that's why we assert it up front before going through the claims. But if you go through the claims as well, you don't find evidence of intent to take anything from Roach. And I think what is the difficult thing for me to understand in reading his petition is it often changes. Sometimes he's saying what I was deprived of was my equity interest in RBS LLC. Sometimes he's saying I'm deprived of assets like unknown grapes or wine. And it depends on the argument which one he asserts. For example, we say, well, if you're deprived of the assets, the grapes and the wine that you claimed were owned by RBS LLC, they must be a party or you can't prevail. And then in his brief, he says, no, I'm actually asserting that my equity interest is what was taken from me. And we say, great, that equity interest was dissolved in December of 2013. And then he says, well, Constellation knew about that. They didn't purchase RBS LLC, they purchased Schrader Sellers LLC 4 years later. So it's a myriad of things. And what I read the brief to do is basically recite the elements of each of the claims to say, they intentionally did this, they knew this, but it doesn't have any substance to it. It doesn't explain what the clear and specific evidence of intent is for even Fred Schrader, much less for Constellation years later. And that's difficult. I think it's difficult for my client, Fred Schrader, because this is his former lawyer and best friend. And so it is also difficult to understand when you have a dispute where one person says 20 years ago they invested, another person says 20 years ago it was a loan, and there is no writing that you could then all of a sudden say that anyone who purchases another LLC that's related to one of those people somehow is buying something illegal. It seems the whole purpose of the statute of frauds, the whole purpose of being on notice or doing due diligence, especially of a lawyer. We'd also like to point out that some of those claims, and unfortunately, and I'm sure the court doesn't want to go through each one of them today, but when you do analyze them, and I'll take an example, the fraud claim against Constellation. Mr. Roach says Constellation defrauded me because they made material misrepresentations to me and I relied on them, and it doesn't explain. I don't know what the fraud is. I'm not sure what the lie is. Is the lie denying that they found any ownership interest of Randy Roach when they did their diligence? If that were true, every defendant would be guilty of fraud by just denying a fraud claim. Is it that there was some intent to do a wrongdoing by merely doing a by doing a transaction of buying a company and having an NDA as part of the diligence? That's not fraud. That's the difficulty. But the reason why we focus on the affirmative defenses is because when you look at those, they either fall into 2 buckets. Either he was defrauded 2002, 2003, when his money was commingled, or when the entity was dissolved in 2013, or he's seeking something in some type of relief that he cannot get in a Texas court, such as dissolving a California cell of a California LLC, or reinstating a California LLC such as RBS LLC. I think this court essentially dismissed all of the declaratory judgment claims under personal jurisdiction because they are all involving California conduct. But to the extent it didn't, the court we asked to look at, is there really evidence of something that a Texas court can and should do regarding Roach's interest in this case? And what is that? Is it giving him the company? And quite frankly, it's a different company. It's Schrader Sellers LLC. It's not Roach Brown Schrader LLC. Is it reinstating Roach Brown Schrader? That's the difficulty of his complaint, or his petition rather. Finally, I will point out that Some things that are missing from the petition are clear in the record. And this court's allowed under the TCPA to look at the entire record under de novo review, including what was the TCPA motion by the appellants. For example, the fact that Roach was paid back $150,000 in 2010 maybe would have put him on notice that he didn't have interest or an equity interest. Or maybe the fact that he was told it was going to be dissolved. He's not offered an alternative explanation as to why he didn't do his diligence or why he should be entitled to something that most people would not be because they don't have a right. At the end of the day, my clients have an interest in petitioning the government and selling things in the ordinary course of business without being chilled just because they did it in a normal way. And applying to the PTO for trademarks used for 16 years, entering into a transaction with an NDA, when you receive a demand letter denying that there was something nefarious when there wasn't. Those are things that should be protected and not chilled as they were by the Fifth Amendment petition. Thank you.
Thank you.
Please, the court. There are so many issues in this case that I know the court may have questions. I mean, if you look at all the sub-issues, including every cause of action, we're dealing with somewhere around 30.
I could use a diagram.
So I think I'll try to do what appellant did, and that is focus on where I see that you can group most of this together and accomplish the most. Three issues. The first, I want to talk about jurisdiction first because there is a new panel opinion and the original panel opinion in the companion or the related case. Came out after our brief, so we really haven't had the opportunity to address the analysis of that panel in connection with the new claims. On the second issue, I want to talk about why the TCPA is not triggered, and the third, because appellants focus so much on limitations when we talk about limitations.
Can I direct you to your second question, because that's really jumping out at me. Does it matter which version of the TCPA applies? Like, in the end, is the analysis the same?
It's similar. What's different about the new TCPA is that the court took out the relating to language for the TCPA triggering conduct and replaced it with based on, which requires, I think, it's a narrower focus. I'm not sure it matters on this case because I don't think any of this conduct is relating to, any of the claims are relating to the TCPA triggering conduct. But that's the difference between the two. So on jurisdiction, first of all, let me say, there will probably be a petition, probably two petitions for review on that panel opinion, and in the out of judicial economy, this court may choose to wait and see what happens in the Supreme Court before issuing an opinion. But that's entirely up to this court. It's very important to focus on the new claims. I'm going to group them into some categories and explain why there is jurisdiction under the panel's reasoning in that opinion. The first category of claims is claims against Constellation. There is no personal jurisdiction challenge against Constellation. I think that's sometimes unclear in the briefing, and so it would be improper to dismiss any claims against Constellation based on personal jurisdiction. The second category of new claims are those that relate to what I would characterize as ownership, the partnership, quantum merit. And these are count M, which is partnership, count N, which is breach of contract to a partner in RBS. There's count K, which is a declaratory judgment regarding Roach's ownership, and there's count P, which is quantum merit. The panel's opinion focused on two categories of conduct that created personal jurisdiction over fraud. And I think those same categories of conduct apply to these claims. The first is representations by Schrader at wine events in Texas. Those are the misrepresentations that are the basis of the fraud. but they're also core to the partnership claim, because the key dispute on the partnership claim is whether there was actually partnership. And one of the factors that Texas courts look at in determining whether there is a partnership is were there expressions of intent to be partners. A good cite for that we did not include in our brief is Ingram versus Deere. It's Texas Supreme Court 2009 288 Southwest 3rd 886 at page 895. And what the court said is expressions of intent to be partners include, for example, the partner statements that they are partners, or one party holding out that the other party is a partner. And that's exactly the jurisdictional conferring conduct that was the first step of the other panel opinions analysis. The second aspect of that analysis is conducting partnership business in Texas. Schrader had events with Roach that they did together, as this panel's opinion recognized, in part of an effort to get extensive business in Texas. So slip opinion at 26 and page 26 walks through this. Roach and Schrader attending events to promote the RBS wine. And those are a substantial basis for the quantum merit claim. What Roach is claiming, the services he provided that he did not get compensated for, include those promotional events in Texas with Schrader acting together, which is what helps confer jurisdiction over Schrader on those. Now, there's a third category of claims, and those are all related to fraud, and there's two of them. Count J, which is setting aside Constellation's acquisition, and Count X, which is a declaratory judgment regarding indemnity. And they're related for different reasons. Count J is based on the same fraud. It's a remedy. It's really not a separate cause of action. It's a remedy just like constructive trust, which was the issue that the other panel addressed on rehearing the new opinion this week. Count X is a declaratory judgment regarding the indemnity agreement, which may not sound like it is related to fraud, but if you look carefully at the allegations in Count X, it's based on the same fraudulent conduct. The pleadings say it's based on a collusive agreement to falsely claim ignorance of Roach's ownership when Schrader repeatedly represented that Roach was an owner. And those are the same misrepresentations that are the basis of the fraud claim. So that's why, and we have not had the opportunity to brief these issues. If the court would like briefing, we're more than happy to do it, but I think that concisely summarizes why there's jurisdiction over those. On the TCPA, I want to walk through the TCPA, the conduct that appellants claim confers or triggers the TCPA. The first is a trademark application. It is barely mentioned in the petition. And most of the, I think there's 3 mentions of it, most of the same mentions appear in the Fourth Amended petition that there was no timely TCPA challenge to. So it's the same essential facts. But, you know, those are not, the trademark application are peripheral. They're facts that help show fraud was going on, but they're not a basis of the fraud claim. Roach is not trying to cancel the trademark. His allegation in the petition is that defendants failed to disclose the trademark, and they were hiding something that he owned. And so that's not something, because we're not challenging the trademark application, it's the fact that there's a trademark out there is not something that would trigger the TCPA. The LaBarge letter, the letter that has to do with responding to Roach's demand on conversion. That letter, we specifically talked about it for the first time in the Fifth Amendment petition, but in the Fourth Amendment petition on the conversion claim, and that's all it's offered for, on the conversion claim, we pled generally that Roach demanded return of his property, which is an element of conversion, and that Constellation failed to return the property. In the Fifth Amendment petition, we just specified that the LaBarge letter was proof of that, but it's the same essential allegations. There's no new allegations.
Well, isn't that enough, though, under the plain text of the TCPA to sweep in claims that are based on that allegation? I mean, if you say, there's a demand letter, that it seems like there's a lot of case law that says that claims based on a demand letter or pleading a demand letter, as part of the basis for your claim is enough to sweep you in. Is that not the case?
Well, we pled the demand letter in the Fourth Amendment petition. We pled that there was a demand.
Okay, so your allegation that there was a demand is a reference to that demand letter.
Right. It doesn't specifically say the LaBarge letter.
So is that enough to put them on notice that they should have filed their TCPA at that point?
I think so. And I mean, with the cases, there's a long line of cases on this. Is where the new allegation is based on the same essential facts. It doesn't trigger a new TCPA deadline. And so this is the same essential fact, which there was a demand. So that's the essential fact. There's a demand. Fifth Amendment petition is a little more specific. Oh, it's this letter by LaBarge, but that doesn't change the fact that the same essential fact is pled.
But aren't
Sure,
there
please.
allegations, specific allegations in the Fifth Amendment petition that reference representations made in, I'll call it the LaBarge letter? In other words, that would be separate from what was stated in the demand letter. So
I think that's right. Yeah, if they were not replicated in the Fourth Amendment petition, I think the court could say that the TCPA applies, but only to the limited new allegation, to the extent it's that any of the claims rest on it. So this is an important point, because case that the appellants have cited, Montelongo, Texas Supreme Court case. What the Supreme Court says in Montelongo is when there's a new allegation, it triggers the TCPA and the potential dismissal of the claims to the extent they're based on those new factual allegations. So if this court were to decide that there's something new that we alleged about the LaBarge letter, then the TCPA might apply to that, but only to the extent that an aspect of our claim is talking about the LaBarge letter. Now the courts look at TCPA on a claim-by-claim basis. It's not the whole cause of action. It's on a claim-by-claim basis, and if the TCPA is triggered as to a claim or a part of a claim, then that's the only part where the court should be doing the subsequent TCPA analysis of whether the claim should be dismissed. There's the association claim based on the contract between Schrader and Constellation. And that is a classic, they call it a public sale. It's not a public sale. It wasn't in the securities market. It's a private, secretive sale. There's a non-disclosure agreement between these two parties. And that's not the type of activity that triggers the public interest that's required for an association of parties in a TCPA. It's not like, for instance, a contract regarding medical research or something like that that's in the public interest. There's two other allegations, sort of generally, that the Fifth Amendment petition is somehow a retaliation for a grievance and for some threatened California proceedings. For that sort of thing, there really has to be circumstantial evidence to show that it's retaliation, and it makes no sense that Roach would just be filing these claims in this multi-million-dollar lawsuit, these very serious claims, in response to an attorney grievance or in response to other proceedings in California, especially where this proceeding was pending long before California. In fact, the California proceeding wasn't filed until after the Fifth Amendment petition. So it doesn't rise to the level of circumstantial evidence that's required to trigger the TCPA.
Could I direct you
Please.
to the next step of the TCPA? If the TCPA applies, and we're certainly not saying that it does, could you walk me through on the fraud claim, the evidence that supports each element?
Yeah, it's really a claim that against Constellation,
Yeah.
talking about Constellation.
Yes.
That they were willfully blind to Roach's ownership, and they entered the transaction anyway to basically take his ownership, and they did it without disclosing it to him, and that prevented him from being able to come in and stop the transaction.
So I guess the appellant here's argued that that some of the elements are only supported by pleadings as opposed to things like affidavits. Is there affidavit support?
I thought there was. Yeah, I thought.
And it's fine if you don't have it
Yeah,
in front of you right now.
but it's the clerk's record 3460 through 3465, and I believe that's the expert's affidavit that walks through the evidence of that.
Okay.
On statute of limitations,
May I, I'm
Please,
sorry
yes.
to interrupt you,
Right.
but just to kind of continue with that same point. So on claims other than fraud, what was offered aside from just the allegations that were alleged in the petition to support the claims against Constellation?
yeah, I think we cited evidence on those. I mean, our brief walks through each of those claims, and I think it's more than just the pleadings. It's the affidavit of the expert, for instance, that deals with fraud. And so I think we presented evidence to support those claims. It's hard to walk through each one, but
There's a lot on the table.
on the statute of limitations, there's a fact issue under the two tolling rules. And when I say tolling rules, I'm talking about the discovery rule and fraudulent concealment. The defendants rely heavily on the Berry case from the Supreme Court. It's a great case, I think, for our position, even though the holding in that case is different, but it's holding on very different facts. And in that case, there was public notice under a real estate statute. There's a statute in the property code, it's 13.002, that makes real property records constructive notice. And so that's what Berry is based on. And we don't have that statute here. But we have some other very different facts here. In Berry, there was a hostile, litigious relationship between the two parties, the party that was alleged to have not disclosed the conduct. Here we had a very close relationship, and more importantly, you had continued assurances from Schrader after the fact that Randy was still his partner, and basically that everything was the same, that he and Roach were still partners. There's an email in which Schrader talks about canceling the LLC. And let me say a couple things about that. First is, there's a real fact issue there as to whether that email would create notice, would give notice to Roach that there was a claim. Because in that email, Schrader says, please read the following, and there's a letter from the attorney, and the letter from the attorney says, essentially, there must be consent by the members of the LLC to cancel it. And the evidence from, I believe, Roach's affidavit is that there was no consent to that. There was never consent to that. And so you also have a follow-up phone call from a lawyer, from Schrader's lawyer, asking Roach if he consented, and Roach never consented. So all of that, none of that suggests that Schrader ever said, I'm going to cancel this without your consent. There's no threat whatsoever of that. And so there's no reason to think that Roach should have known that there was a cancellation based on either that email or the filing in California. But you also have here a fiduciary duty that's owed by Schrader as the managing member of the LLC, and you also have the fact that he actively concealed the cancellation. by these ongoing assurances that they're partners. There's one other thing though, this really isn't the cancellation of the LLC is not what this case is about. We've put our primary theory is that once the LLC was canceled, Schrader continued to have basically hold Roach's interest as a fiduciary. There was a constructive trust, and the injury doesn't occur until the sale to Constellation. And I know appellants have argued that they think somehow the injury occurred, but if you look at the face of our pleadings, and our primary theory is that he continued to hold that interest, and there is no injury until the actual sale occurs. We ask the court to affirm.
Thank you for your time here today. I'm going to go first in the order of the application of the TCPA to this case. The reason why is I think it's a fair reading of the Fifth Amendment petition. At least I read it. It was 75 pages long. The difference was it did say for the first time that the PTO application was in bad faith and for the purposes of committing a tort against Mr. Roach. That is the first time that this appellee based a claim on a petition to the government for the issuance of a trademark. The mere reference to the fact that there were no trademarks prior in the Fourth Amendment petition was not enough to make us clear that that was the basis of his claim. Now, co-counsel argued that somehow this court would then only look at the TCPA on that basis of just that part of the claim, and that's not the law. The law of the Texas Supreme Court in Montelongo is that once the TCPA is triggered, this court looks at whether or not there's clear and specific evidence of each of the claims in question. And for instance, in the issuance of fraud against Constellation, they can't articulate what Constellation's fraud was because there was no fraud. The record cites he cites to you are from the Fifth Amendment petition, and all they are rote recitations of conclusory statements that Constellation kept its diligence quiet and intended to defraud them. But there's no evidence of that. They didn't even know Roach existed. Also, the fact that the Labarge letter is first mentioned in the Fifth Amendment petition is a reason why the TCPA applies. The demand letter that prompted the Labarge response was mentioned before, but that's entirely different. Now basing a cause of action for fraud again, based upon a denial by an attorney saying we didn't do what you said we did, is chilling the right of free speech. It's chilling the right to petition. Why would an attorney ever respond to a demand letter in the future if they're going to use the response as the basis for their fraud claim?
But isn't that a question for the legislature?
That's why I think the legislature made it so broad. The right to petition doesn't require public concern or any of that. It is just a communication and connection with either an ongoing governmental proceeding or one that's likely to happen. And in this case, we have both. We have this lawsuit for the Labarge letter, and we have the PTO's review of the application for the trademark. And so that's why I think the legislature wrote it that broad. That's also why the Texas Supreme Court issued the Youngkin case, where an attorney was sued for his communications about an ongoing case. That's why the TCPA is triggered. What essentially we had here is after the Fifth Amendment petition came out, because it was intended to chill the actions of my client in this case. By hiring the same attorney, they were sued, and the assertion that the indemnity is somehow illegal is also chilling. And so all of those are new. The suggestion that they are not part of the TCPA, I think, would require ignoring the plain language of the statute. As far as the issuance of personal jurisdiction, I'll just say this briefly. I think the court's opinion is very lengthy, very well reasoned, and it explains in detail why the partnership and the core of that dispute is all in California and not in Texas. Trying to rope it back to Texas just because there were dinners in Texas you would have to take as true the tort claims that they're saying, and Ms. Gianna Living said you can't do that. And so the only reason the fraud claim survived is because there was a separate allegation of business dealings by Mr. Schrader. That wouldn't apply to these other claims, including the new claims that they've mentioned. And finally, on the statute of limitations defense, to point out that the Berry opinion did not just say because it was a statute that says you're on notice of a public deed record. It said all public filings can cause constructive notice of someone to know their rights are injured. It also says that there is a duty to monitor by people their rights of public filings. It was not confined to deed records. And there's also the overarching concept that the discovery rule and fraudulent concealment still are not triggered if something is, unless something's inherently undiscoverable. It is easily discoverable. And a 10-minute internet search is what they've said in their petition to find that the LLC was dissolved. And so there's no way that fraudulent concealment can exist after the solution was public and after they were on notice through an email that it would happen. And the whole point of this is that this is a 20-year-old handshake agreement. And we're fighting over what they said 20 years ago that no one can prove because there's no writing. That's the whole purpose of the statute of limitations, because after some point in time, it becomes too difficult to litigate. I appreciate your time.
Thank you. Thank you for your arguments. The case is submitted.
All rise.